Second Amendment Foundation seeking the U.S. Supreme Court to review a ban on semi-automatic firearms. It is Illinois in Focus Daily. I'm Greg Bishop. We've been tracking gun ban litigation for years now. Not just the Illinois ban that was implemented in January of 2023, but also you had the Cook County ban, and that was put into effect years ago. A challenge in 2021, Viramontes v. Cook County, that has gone through the district courts where they sided with the county. It went through the appeals courts where they sided with the county, and now the petitioners are going to the U.S. Supreme Court saying that they want the court to decide this question. I talked with Alan Gottlieb from the Second Amendment Foundation briefly yesterday, and here's some of what he had to say is the importance of this case and the importance of getting this issue resolved quickly.
This case was originally filed in 2021, so it's been a long time on hold, so to speak, and we've now been able to file our cert petition with the United States Supreme Court to hear this case on the Cook County assault weapon ban.
So with all of that, you've got, the Viramontes case filed in 2021 before the state's gun ban was actually put into place. So that's now queued up for possibly going to the U.S. Supreme Court. They have to put it into conference and decide if they're going to take this case. But we have the Barnett case, and that's the consolidated case challenging Illinois' gun ban. The entire statewide gun ban for plaintiffs groups under the Barnett umbrella. That was in the district court and went to the appeals court on preliminary grounds, even went up to the U.S. Supreme Court on preliminary grounds, but the Supreme Court said it's not ready yet. Then it went back down to the district court in the Southern District of Illinois, 4-day bench trial, thousands of pages of documents and testimony, and just a lot of substantive record in the Barnett case. The Viramontes case, not so much. And I want to pull up just, the order, for instance, from the Viramontes case out of the appeals court. And this is what it looks like. It's a 6-page document that includes all of the various, things that they have to deal with when they're dealing with court cases. So they say that Cuberto Viramontes and Christopher Kaya, together with the Firearms Policy Coalition and the Second Amendment Foundation, appealed the decision of the constitutional challenge of Cook County's assault weapons ban, relying on the District of Columbia versus Heller and New York State Rifle and Pistol Association. They argue the ordinance is facially invalid under the Second Amendment. We addressed a similar challenge to the ordinance in the case Beavis v. Naperville. We rejected the challenge based on the record the plaintiffs have compiled in the early stage of litigation. Challengers that failed to develop a record sufficient to justify a different result. We therefore affirm Cook County's ordinance prohibits the possession, acquisition, and transfer of assault weapons. The law applies to a variety of firearms, including semi-automatic rifles capable of accepting large capacity magazines and possessing certain features. Goes on from there, spelling out how the case was developed and the appeal that happened. And you can read some of this as I scroll through. But ultimately, you have the appeals court siding with the district court, which upheld Cook County's gun ban. So that's where the Viramontes case is right now. But what about that Barnett case, right? I mean, the record in the Barnett case, 7,000 pages of evidence and testimony, 4 days of bench trial with all of the transcripts there. Talking with Alan Gottlieb from the Second Amendment Foundation, he says that, listen, this is all going towards one direction, and that's addressing the issue of can governments ban certain types of firearms.
Well, they're similar. One is on the Cook County level and one is on a state level. If either one gets struck down eventually by the United States Supreme Court, they're both going to be history. The Supreme Court has indicated its interest in addressing the assault weapon ban in the next term or two, and we think this is a solid vehicle for that review.
Solid vehicle. Some may say, well, just wait for the Barnett case. We'll touch on Alan's response to that in a moment. But all of this comes as you've got a mass shooting that happened in Minneapolis, where it's just an absolutely tragic story. Here is just some of that instance in the news that happened yesterday.
Earlier today, just before 8:30 a.m., our city experienced an unthinkable tragedy. Minneapolis police officers responded to a report of a shooting at a mass that was happening at the Annunciation Roman Catholic Church on the block behind me. This worship service was marking the first week of school for children that are attending the Annunciation Catholic School. During the Mass, a gunman approached on the outside on the side of the building and began firing a rifle through the church windows towards the children sitting in the pews at the Mass. Shooting through the windows, he struck children and worshipers that were inside the building. The shooter was armed with a rifle, a shotgun, and a pistol. This was a deliberate act of violence against innocent children and other people worshiping. The sheer cruelty and cowardice of firing into a church full of children is absolutely incomprehensible. Police officers from the Minneapolis Police Department immediately responded, entered the church, and attempted to provide first aid and rescue some of the children that were hiding throughout the building, while other first responders came and EMS responded to rush victims to nearby hospitals. 2 young children, ages 8 and 10, were killed where they sat in the pews. Their parents have been notified. 17 other people were injured, 14 of them being children. 2 of those children are in critical condition. The coward who fired these shots ultimately took his own life in the rear of the church.
So you've got just a tragic story here, and we hear these just horrifying stories time and again where there's a mass shooting, and then you get the follow-up reaction from some, like, for instance, Governor J.B. Pritzker. And I only share this because this is a line of defense that the state and the county has taken as to why they feel they have the ability to limit a constitutionally guaranteed right of keeping and bearing arms, the Second Amendment. Unprecedented societal concerns of mass shootings. That's one of the things that we're going to hear in the debate in oral arguments on the 22nd for the Barnett case, and likely if the Veramontes case is heard by the U.S. Supreme Court, that's going to be one of the arguments, and Governor J.B. Pritzker essentially reiterating that yesterday when he was asked about the shooting in Minneapolis.
Earlier today,
and let's go to the governor over here.
It's awful. This is a pre-K to 8 school. I reached out to Governor Walz to let him know that we would do whatever it is that we can to help him. He should just let us know. I also, of course, expressed my condolences to him and to the families of the victims. And, of course, the victims themselves. There are people who've been wounded, as I now understand, as well as, of course, some deaths. So it's a horrible tragedy. We have too many guns out there on the streets, and we have, unfortunately, a situation where, there are kids and adults who need mental health and substance use treatment, who are often the people who ultimately they can get a hold of guns. We ought to stop that, but they can get a hold of guns and then commit these terrible crimes.
So, just to kind of show you how a certain side of the political aisle thinks about gun control after these types of attacks. And, we can get into the identification of the individual who took his own life. He apparently, as a minor, had his name changed to a female gendered name, and just let people kind of deal with that however they want to. But we're looking at whether policies coming from the state or county can limit individuals' Second Amendment rights. And to that idea of the unprecedented societal concerns, I asked Alan Gottlieb from the Second Amendment Foundation to react to that, or what's the counter? Why are they wrong that unprecedented societal concerns over mass shootings is a reason that they can ban firearms?
Well, there are concerns about lots of things. You could use a car to do, a mass killing as well, what we've seen happen around the United States where people drive into crowds and kill people. But it doesn't, in this case, it's a constitutional right to keep and bear arms. Just because there's concerns in society doesn't mean you shred the Constitution. You wouldn't do it for First Amendment grounds, and you shouldn't do it on Second Amendment grounds either. Another
argument that the defenders of gun bans likely will take in the oral arguments, and we've already seen it filed in the briefs in these cases, and that is that these firearms, they say, are dangerous and unusual. Gottlieb says that's really not the case.
Well, I think any gun can be dangerous. In order to be meet constitutional muster, they have to both be dangerous and unusual. And these so-called assault rifles, the semi-automatic firearms, are not unusual, and they're not any more dangerous than any other firearm would be. So these people that are making that argument really would like to ban all guns if they could get away with it. And that's just not going to hold up when the Supreme Court hears this case. I think we're going to be on solid ground. And I really believe they're going to take one of these cases, and this one could be the vehicle.
So it could be the Viramontes case challenging the Cook County ban. Or we could have to wait for the Barnett case to get through the appeals court process and then get queued up to be petitioned to the U.S. Supreme Court. And in the Barnett case, on Friday, this was filed by the plaintiffs dealing with a different district's outcome of a gun-related case. Here's the filing in the Barnett case. Harrell appellees bring to the court's attention the Sixth Circuit's recent decision in U.S. versus Bridges. In the case, defendant argued that his conviction for possessing an automatic weapon should be reversed on Second Amendment grounds. The Sixth Circuit affirmed the conviction, but it rejected the reasoning of Bevis v. Naperville and created a circuit split. So, applying Bruin, the Sixth Circuit concluded that automatic weapons are arms within the plain meaning of the Second Amendment's texts. Though the modern fully automatic machine gun would not be invented until 1884, the word arms in the Second Amendment extends to all instruments that constitute bearable arms, even those that were not existing at the time of the founding. Indeed, to the founding generation, all firearms constituted arms. Thus, the Second Amendment's plain text covers Bridges' possession of a machine gun, even though the courts later concluded that barring possession of automatic machine guns was consistent with the historical regulation of dangerous and unusual weapons. Goes on to talk more about how the judge there's concurrence explicitly stated why the panel opinion was inconsistent with Bevis. In Bevis, this court, the Seventh Circuit U.S. Court of Appeals, held that dangerous and unusual weapons aren't even arms within the Second Amendment's meaning, but that analysis did not faithfully implement Bruin's instructions because concerns the semantic content of the Second Amendment's text. Thus, judge in this particular case agreed the majority on this is an important point. So you've got that filed in the Barnett case, just letting the Seventh Circuit know, listen, there's this other circuit over here that's kind of going up against what you guys had previously said. So the Barnett case, again, we've got September 22nd when that case is going to be heard in the appeals court, and that will be streamed live, I believe, at the Seventh Circuit U.S. Court of Appeals YouTube page. So that's going to be interesting to hear that play out, especially, again, because you've got the difference between the Viramontes record and the difference between the Barnett record. The Barnett record's 7,000 plus pages, hours of testimony during a 4-day bench trial, and a record where the district judge found the law unconstitutional. And the state is having to defend the law in the appeals court. Gottlieb says that the cases need to get moving. And here he is in 5, 4, 3, 2, 1.
Is a right delayed is a right denied. And so any case we can get to the Supreme Court quickest is the ones we're going to push. We're obviously going to push all of them, but our interest is getting it heard as quickly as possible.
So he says a right delayed is a right denied, and we'll see where these cases go. But again, we'll be tracking it here with the Center Square. So be sure to get the headlines in your inbox each morning at thecentersquare.com/Illinois. Wake up with us here for Illinois in Focus daily, each and every weekday morning for the latest. And if you can't make the live show where the live chat is a poppin', well, get the podcast where you get podcasts uninterrupted. You can listen to it while you're doing chores, driving around for Labor Day weekend, just hanging out with friends. Put on Bishop. Let's see what Illinois in Focus with the Center Square's got going on. It's probably not the best listening next to a campfire or something. All right. Right here each and every weekday morning. Appreciate you guys being with us.